Chair recognizes Senator the Honourable Fred Mitchell.
No. Thank you, Madam President. As I understand the regime of this bill, it says that, I'm just reading from 7.3, where any certificate has been issued, the person who receives the same and any in-house professional designated by him in writing may freely enter the Bahamas for the purpose of setting up or conducting such a specified commercial enterprise in reliance upon the said certificate. So what that means, I take it, is you get the certificate from the board, you come to the border, wave that at the immigration officer, and then you come with the people that you need to set up your business. That's the way it appears. That's fine, but that's the way it appears. You come to the border, wave the certificate, my words, wave the certificate, and in you come. It says must be freely, I use the word wave. Okay. Then it says, any person entering the Bahamas pursuant to 7.3 shall within 30 days of such entry submit a completed application for a work permit to the Department of Immigration in accordance with the Immigration Act and attach a copy of the certificate with the requisite documentation thereto in 8.1. So that means on day 30, he doesn't have to do anything for 30 days. On day 30, he can then make an application. Apropos your point about it's all done by the time it's all approved. So he can wait until day 30 before he makes the application. That says, 8.2, the Director of Immigration shall determine any work permit applied for not later than 14 days after the filing thereof and the payment of the application fee, failing which the work permit shall be deemed to have been granted pursuant to this Act and may only be later revoked if the Director has reasonable grounds for doing so on the basis of public safety, public morality, national security. So that says that after the 30th day he applies and 14 days after he applies or working days after he applies, if he doesn't say yes, it's deemed to have been granted, and then it goes on in 3 to say any person whose application for a work permit has been deemed to have been approved shall forthwith be issued with the work permit. Come back to that in a second. But the point in 8.2 is that it will be deemed to have been granted pursuant to this Act. So that's the public alarm. The public alarm is that people will be getting work permits automatically. That's the word that's going around, and that's the public alarm. And the issue which I raised publicly is this, and may only be later revoked if the Director has reasonable grounds for doing so on the basis of public safety, public morality, or national security. And I ask myself, why would I want to circumscribe the present powers of the Director of Immigration? Who can act today for someone who is not a permanent resident or a citizen of the Bahamas and say, for reasons unspecified, doesn't have to give a reason, out you go. In other words, if the Director understands public safety, public morality, national security, he does not have to disclose those reasons today. And we are now going to circumscribe this power, and the Act is going to make a reviewable jurisdiction. Because once you put in there reasonable grounds, and then you say public safety, public morality, national security, it appears that it anticipates that the Director will have to disclose what the reasons are. Fine, I'm only saying begging for trouble down the road. All right, 8.3. Any person whose application for a work permit is deemed to have been approved shall herein forthwith be issued with such work permit and immigration card subject to the terms set forth in subsection 4. Now, the point I want to make at this juncture is forthwith. Paper can stand still for anything to be printed or written on it. What does forthwith mean in practice today at the Department of Immigration? Even if you say forthwith, the card takes upwards of 6 weeks for them to produce the card today. 6 weeks. So, and the reason I'm making that point is that everything that I have heard today from the government side and the criticisms which have come from the civil society representatives in here and our own critique of the bill suggests that the real issue here in a discussion about immigration, it's just efficiency. It's just efficiency. You don't have to construct this whole infrastructure and enterprise to deal with that problem of whether someone gets a work permit quickly or not. And we knew that. That's why we spent or allocated $18 million for a border management system to try and improve this. First, the passports. Canadian banknote is still here, as I understand it. It's a 5-year rollout to do just that. So you can apply. You can apply online. It's paperless, and you can track where the application is, and you get your work permit in short order. As a matter of fact, even with the inefficiencies of the system today, someone entering the Bahamas today can be issued at the border right now. An immigration officer can give you a work permit right now, 7 days, and it can be extended right now. The director can give you 3 months as a temporary right now, and people do it all the time. So I'm saying this seems to me using a cannon for which a fly swat is necessary, which is the big thing. And you have a majority now of 35 to 4. I beg you, as they say in Jamaica, I beg you, use the power you have to reform the public administration. That's the issue here. Everything is too deliberative. Everything takes too long, so on and so forth. The IDB told us, and my proposals got booted out the first time I was public service minister, for one thing. Too many things get sent up to the cabinet for decisions. Too many things. But what are people, I don't know if you still do it, but you're still sitting around deciding whether you can go to Miami for $250.
Now we tried this.
I mean, this is ridiculous.
It's over. You can't stop it.
I mean, goodness gracious, you know, what is this? You know, $1 billion corporation you're running, and 21 people sitting around saying, oh, you know, folks going to Miami, is he gonna, you know, and how much you getting for per diem? You know, well, this is crazy. Exactly. No, this is absolutely nuts. Absolutely nuts. And so that's what I'm saying. That's what I'm saying is the direction which we ought to be going, is reform of the public administration in this matter. Now, work permits. It says in 7(1)(b), work permits requested are required for an executive or manager, and this is the one, individual with specialized knowledge relating to the enterprise. Well, boy, I could see all kind of specialized knowledge, you know, all kind of specialized knowledge. And then, of course, yes, of course you do, but you know, what I'm saying is you're all anxious to please at the moment, so presumably you've got people lined up at the door, and the applications will come in and you'll be busy stamping away to get things, you know, just, you know, jobs. And look what's in the list. You concentrated on captive insurance, reinsurance, mutual fund administration, arbitration. But the ones that jumped out at me are computer programming, software design and writing. Now, I know that there are young people in this country who make a living today doing this from their homes. And I would not want to be part of supporting anything which is going to create competition for them. And that's what this legislation begs. That you're going to have some fellow who decides, oh, you know, my kids went to school with him in Miami. I think I'd go over to the Bahamas. I need to, you know, $250,000 spare change in the U.S. these days, given inflation and all the rest of it. And they're here setting up these businesses in competition. And it only takes 1 or 2 people. And you just get to be in the Bahamas. And that's the deal. So the thing that you anticipated about foreign currency is not what you desire, or will not have the desired effect. But instead, that's what we mean by undercutting the market when we look at these various things. Those 2 in particular, computer program, software design and writing, even nanotechnology. And the one about call centers. You know, Yeah, I know, there is one doing very well. So that's the issue for us, is when we say undercutting the market. The other point, though, I wanted to make with regard to this, and this may be when you reach the committee stage. When you look at 7.4, it says, where any person entering the Bahamas pursuant to subsection 3 is a holder of a passport issued by a country for which a visa in accordance with the Immigration Act's Chapter 199 is required for entry into the Bahamas, that person shall apply for and obtain such visa prior to entering the Bahamas. No issue, except that the Immigration Act is not the act which requires visas for the Bahamas. The Ministry of Foreign Affairs Act is the act and gives the power. As a matter of fact, I was trying to look it up, and so I just say to you now that the Bahamas, the site of the Bahamas government does not have the current legislation as it relates to that act. But it is actually number 50 of 2014, which imposes visas. And section 7.4, in my view, ought to comport with that actual fact. I'm not sure that anything turns executively on the bill, but it should accurately reflect. You ought to check on it. Now, Madam Vice President, we are going to vote against this bill, and we believe that there are good and sound reasons for doing so. I was a little taken aback by the start of the senator who is the leader for the government with regard to this question of race baiting. Because as I see it, no one has said anything about race in this debate. No one has once mentioned it. Now, the only people who seem to have called race were the members for the government. What we have said is that certain people have to admit to their history. It is what it is, and you can't deny it. If someone is the son of the premier, of the first premier of the country, he was. That's it. And that doesn't change. That's the history. The fact is, majority rule, it came in 1967. There was an Immigration Act passed in 1967. And that Immigration Act in 1967 brought in a policy regime which said this: a Bahamian must have the first call on the resources of this country. And the only way a work permit is going to be issued is if a Bahamian is not available for the job. That has been the policy for 50 years. That's the policy. And that is, if you want to call it, the old-time religion. And as we say in church, if it's good for Paul and Silas, it's good enough for me. If it's good for Paul and Silas, it's good enough for me. So, the point I'm making is this. The fact is that there has constantly been an argument between the sides in the country with regard to what the policy on immigration ought to be. And, sorry? The policy on what the policy on immigration and work permits ought to be. If you look, for example, at the Immigration Act as it was amended in 1970, it says this in Section 3 in the now 1967 Immigration Act. Notwithstanding anything in any enactment to the contrary, any provision of any agreement to which this section applies, which constitutes or purports to constitute any undertaking on the part of the government of the Bahamas to allow, subject or not to any conditions, the entry of any person or class of persons, or B, any person to bring any person or class of persons into the Bahamas for any purpose, shall, with the effect from 6th May 6 March 1970 be null and void for all purposes, and in particular shall not be capable of affording a defense to any person charged with an offense under any enactment, nor affect in any way whatsoever the application or construction of this act or any other enactment. And any such agreement as foresaid shall, for all purposes, be read and construed as though it did not contain such a provision. This is the Immigration Act, Section... the Present Immigration Act, Section 3. Now, the reason that was passed was because of the argument over the Hawksbill Creek Agreement. And this amendment nullified provisions of the Hawksbill Creek Agreement Act, which purported to give the Grand Bahama Port Authority the say over who was going to come into the country. And that's what they did to nullify that.
They were nullifying a private agreement.
That's fine. But what is interesting is that when you look at what the provisions in the Hawksbill Creek actually said, it actually mirrors these same provisions that you have here. Actually mirrors them. What was agreed.
But it's a private entity.
I understand.
Not the government.
I understand.
Government.
I understand. I understand. I understand. I'm saying it mirrors. So what I'm saying is this is a long-standing argument between the sides as to how you actually deal with this problem. And again, I say, when you look at the experience on all of this, the issue is really efficiency. Efficiency, efficiency. And that is what you ought to concentrate your energy on.
It is being.
Now, there was a video, and Senator Darville adverted to it during his statement. There's a video which is circulating about Grand Bahama.
Oh, yeah.
And it's at the front of the shipyard. And I mention this because this is a point which came home to me when I first got this job as Minister for Immigration. We called in the shipyard. There are a couple other companies, Quality Services and a number of others, and said, look, we all remember 1969. The opening of Borco, what the Prime Minister said, which led to this revocation in 1970, to clarify who controlled immigration in Freeport. But I said to them, look, we have to have a social contract amongst ourselves. It cannot be that these youngsters from 8 Mile Rock and Freeport can see people jumping on a bus every morning, going in through the gate, and they are looking outside the fence. And they're looking at jobs which can be done with a minimum of training by Bahamians. There's no reason to have them there. The companies resisted. Oh, well, you know, sometimes it's cyclical. Bahamians don't like to be there. Welding, they said things about the kids smoke marijuana and so on and so forth. Anyway, we worked with them. And a program was put in place for the training of people in the shipyard so that they can take these jobs. Now, of course, the question is, what is happening? Has that program fallen into disuse? And the reason why I mention it is because the point which Senator Darville makes is that monitor. How do you monitor programs to be sure that employers follow what you say you're going to follow? So you have in this bill, you have a regime that you lay out, an agreement between the two sides on what is supposed to happen with regard to work permits and training. But again, the question is, who is going to monitor this? And I raise this because we found ourselves in a disability when I served as Minister for Immigration, because Bahamians would come and complain to the Department of Immigration about specific abuses by foreign employers against Bahamians. And the Department of Immigration, 300 souls strong, does not have the infrastructure, the capability, or the ability to investigate those complaints. In fact, some might say they don't even have the legal jurisdiction to do it. So what we would do as a matter of routine is we would refer the complaints to the Department of Labor that has the power to summon employers, that has the power to call for records, and have an investigation of what was going on these sites. And that was as close as we could come to monitoring it. Sometimes when we issued work permits, we would say that you're supposed to have an understudy, because at one point there was a policy of the Progressive Liberal Party's government that you could only get three-year work permits, and then you had to leave. And that was because the threshold for permanent residence was 10 years, and you didn't want anybody to stay to be able to claim under that 10-year rule. But the Ministry of Labor would come back, and then the Director of Immigration would act based on the complaints that the Department of Labor either certified or understood was happening. So that was the way we dealt with that. But the question, again, is monitoring. And I'm concerned because I had announced as minister at the beginning of the year that I thought that the Department of Immigration should triple its size, because 300 was certainly not adequate for this country. And we were able to take on, I think, just over 200 officers. And I read some in the newspaper that the current minister said there's nothing for them to do, and, you know, maybe they have to lay them off, and so on and so forth. Yeah, immigration. And I'm saying that if you are, even the small things that you expect to do with this bill will require the manpower and the machinery. If you want this thing to work expeditiously, will require the manpower and the machinery. And so I'm saying that, first of all, these immigration officers, their jobs ought to be retained. But secondly, the immigration officers ought to be trained to work along with the Department of Immigration in some of these functions. Therefore, it is important for us to remember the historical situation with regard to this country. And it is, you know, we've said that the person who is pushing this bill, who is leading this bill, the irony is that 50 years after majority rule, this is the man who's pushing the bill. Pushing the bill.
I'm sorry. I'm sorry, Madam President. I have to say this. This is a government bill. It is being pushed by government members. It is being pushed by FNM members of Parliament in the other place, and a host of government ministers are speaking to the press, to the media, to civil society about the bill. It is an unfortunate comment, and I would ask my friend on the opposite side to consider shifting or changing that and stop trying to make it appear that this bill is the purview of any one minister, and that one minister being the target minister, okay, or that has been targeted by members on the other side. Thank you.
Madam, the person who wound up the bill in the lower house, the person who has been speaking about the bill. Yes, right, but I'm saying that, and the minister who will be responsible for the bill.
No.
Yes.
Let's just, can you move on? Can you just move on, please, Senator?
Right, yes, of course it is. That's what I'm saying. And, you know, so don't have hypersensitivity about this. That is the fact.
Yeah, but
that is the fact.
But the fact that he...
Madam President, sorry. The fact that the minister is who he is and looks how he looks is irrelevant.
No. Sorry, I didn't go there.
Okay.
I didn't go there.
Fine, I'll take that back part. The fact that he is who he is irrelevant to the proper discharge of his duties as a minister. Ministers act on the advice of their public servants. There are very limited areas where a minister can overrule. But he is always well advised to be guided by his public servants. And other than that, to be guided by his colleagues in cabinet. So it is unfortunate and inaccurate to suggest that the particular minister responsible for this bill is going to be someone who is on some frolic of his own and able to take decisions that do not accord with the policy of the government. Because that is what his job is there to do, to enforce government policy, and that policy is in no way akin to anything prior to 1967. Thank you.
Let me put it this way. We have had particular experience. The country has had particular experience with regard to the issue of conflict of interest before. We have had.
My brother. How did he jump from majority rule to conflict of interest?
No, I mean,
it can't be all over the checkerboard.
Hold on, senators.
It's not all over the place.
Yeah, Senator Mitchell, please please continue. Continue, Senator Mitchell.
What I'm saying is, here you're going to have enterprise zones, and I'm only saying we're going to be watching very carefully what happens to this. This is the point made in the lower house. Enterprise zones means land, right? Who is one of the biggest who is one of the biggest landowners in the country? No. I'm being deadly serious. You know, you need to answer, and I'm saying we are watching very carefully what happens with this, so that that you're not dealing with self-interest in this matter. So that is the point. Those are the points we make with regard to this bill. The bill should be withdrawn, reconsidered, amended. You need to switch your attention away from issues about work permits and deal with the efficiency point. Be careful. Be careful that the country is watching with regard to this conflict of interest point, and that people are prisoners of their history. Just be careful, and we send up a red flag on those areas. The Progressive Liberal Party stands with Bahamians who are concerned that jobs will be protected for Bahamians, and that there's not going to be unfair competition, and that you're not going to be undercutting the labor market. We want to defend the legacy of Bahamians first. We believe that this bill is going to undercut that legacy, and it is important for you to take cognizance of it, to see what the historic experience has been around the country, and amend and deal with the practices. You know, what concerns me is I look in the newspaper, I read the newspaper, and every day you've been saying things, oh, it's not going to operate this way. It's not going to operate this way. We're going to do this. But none of this is delineated in this bill. So you get the impression that you're simply making it up as you go. And that is the thing that concerns us. This is an immigration bill. Immigration is the kind of last bastion of defense for our country. It is said that we are trying to ring fence and therefore not in accord with the functions of the modern economy. But even our neighbor to the United States, you see what they're doing, trying to protect the workers of their own country. And that's what we are seeking to do in a similar fashion, to protect the workers of our own country. And so, Madam President, we will not be supporting this bill. We think the bill is premature. We think that it is undercut the market. We think that the government has rushed to judgment on this. And so, for these reasons, we will not be supporting the bill. So, thank you.